India Legal presents Courts Roundup.
Hello, I am Disha and you are watching Courts Roundup. In this program, we will bring you the latest legal news and detail of the court's proceedings. Before we begin, here are the headlines. CBI opposes bail plea of mining baron Janardhan Reddy in Supreme Court, says Reddy hold considerable influence, can tamper with witnesses. Court asks CBI to file affidavit. In case of allegation against Justice Ramana, Justice UU Lalit recuses from Andhra CM JaganMohan Reddy's case, says I had represented these parties in litigation, cannot take up this matter. Kerala High Court quashes defamation case against Manorama editor, says press has right to publish news item with its necessary comments and views. Supreme Court asks Sameet Thakkar to approach High Court for his release over tweets against Thackerays, says High Court can also hold up your fundamental rights.
India Legal presents Courts Roundup.
The Central Bureau of Investigation has opposed the bail plea of mining baron accused in illegal mining cases, Gali Janardhan Reddy. A bench of Justices Ashok Bhushan and R. Subhash Reddy directed the CBI to file detailed affidavit in this regard. Senior advocate Madhvi Diwan told top court that Janardhan should not to be let out on bail and visit district Bellary in Karnataka, as he hold considerable influence and might interfere with the investigation. He has filed multiple petitions. Witnesses under police protection have been threatened and vehicles have been set on fire. 47 witnesses are there. We don't know what will happen if this gentleman is allowed to enter the area, Diwan said. In August, Supreme Court had allowed the former Karnataka minister and mining baron to visit Bellary for 2 days in order to attend the last rites ceremony of mother of his close associate. We find no merit. The petition is dismissed. A bench of Justices A.K. Sikri and Ashok Bhushan had said while rejecting Janardhan Reddy's plea for modification of the order and grant him permission to stay in Bellary for 10 days and also cast vote in the election. The bench pointed out an order of January when Reddy had made a similar plea and it was rejected. Reddy was made a minister in the B.S. Yediyurappa government formed after the Bharatiya Janata Party won the assembly election in Karnataka in 2008. In the Andhra Chief Minister Y.S. JaganMohan Reddy's case in Supreme Court, Judge Justice UU Lalit has recused from hearing. Reddy had raised allegation against Supreme Court Judge Justice N.V. Ramana. The court was hearing 3 separate petitions seeking inquiry and action against Justice N.V. Ramana. The plea came up before a bench which also comprised Justices Vineet Sharan and Ravindra Bhatt when Justice Lalit remarked, "As a lawyer, I had represented these parties in litigation. I cannot take up this matter. Let this matter be listed at the earliest before any other judge decided by the CJI." The petitioner, who are also 3 advocates, G.S. Mani, Pradeep Kumar Yadav and Sunil Kumar Singh, and NGO Anti-Corruption Council of India Trust, have submitted that the allegation levelled by Reddy against Justice Ramana are baseless. They have also highlighted that the Reddy is facing over 20 criminal cases. Petitioners have sought a judicial inquiry by an internal committee headed by sitting or retired judges of the Supreme Court or any authority including the Central Bureau of Investigation into the allegation raised by the Andhra Pradesh Chief Minister. Reddy in his letter had alleged that Justice Ramana had been influencing the judicial affair at Andhra Pradesh High Court, including calling the shots on roster of certain High Court judges. It was also alleged that cases important to the opposition Telugu Desam party were allocated to a few judges. The Supreme Court has sought the response of the Uttar Pradesh government and UP police in a plea seeking release of Kerala journalist Siddiqui Kappan, who was arrested and charged for offences under Unlawful Activities Prevention Act. A bench headed by Chief Justice of India S.A. Bobde posted the petition, which has been filed by Kerala Union for Working Journalists or KUWJ for further hearing on Friday this week. The petitioner has challenged Kappan's detention, claiming violation of fundamental right under Article 14, 19 and 21 of the Constitution. Earlier, a bench of Chief Justice of India S.A. Bobde and Justices A.S. Bopanna and V. Ramasubramanian had adjourned the habeas corpus petition, asking the petitioners to approach Allahabad High Court first. The court had also asked the petitioner to file an amendment petition. However, the KUWJ informed the court on Monday that not only has the case progressed at the High Court, but Kappan was denied opportunity to meet his lawyers too. Kappan, a journalist working with news portal, was arrested at a toll plaza near Hathras in Uttar Pradesh while he was on his way to cover the gang rape and subsequent cremation of a 19-year-old Dalit woman. Earlier, a bench of Chief Justice of India S.A. Bobde and Justice A. Bopanna and V. Ramasubramanian had adjourned the habeas corpus petition, asking the petitioner to approach Allahabad High Court first. The court had also asked the petitioner to file an amendment petition. However, the KUWJ informed the court that not only the case progressed at the High Court, but Kappan was denied opportunity to meet his lawyers too. The Supreme Court has refused to entertain the petition filed by Sameet Thakkar, who was arrested for making objectionable comment against Maharashtra Chief Minister Uddhav Thackare and Minister Aditya Thackare on social media. Thakkar had moved the Supreme Court seeking consolidation of 3 FIRs registered against him for his post. He had also sought interim bail for the FIR registered at VP Road Police Station and Sitabulri Police Station in Nagpur. Appearing for the Thackare today, senior advocate Mahesh Jethmalani termed the case as one of the most unfortunate ones. Appearing for the state of Maharashtra, advocate Rahul Chitnis said that there was no opposition to the bail application move on the behalf of Thakkar and that custodial interrogation was over. CJI Bobde then made it clear that the apex court would not entertain the plea. When Jethmalani asked the court to record Chitnis' statement, the CJI said, "We find it very unusual that you have to request us to listen to you. High Court can transfer cases and can grant bail." Stating that courts have the discretion whether or not to grant anticipatory bail, the Delhi High Court refused to grant relief to a yoga teacher accused of sexually harassing a minor girl. The accused was charged with committing bailable offences under Section 354A, sexual harassment, and 509, insulting the modesty of a woman of the Indian Penal Code, as well as Section 12, punishment for sexual harassment, of the Protection of Children and from Sexual Offences, POCSO Act 2012. The order was passed by a single judge bench of Justice Pratibha M. Singh in the anticipatory bail plea moved by one Swami Ganeshanand, a yoga teacher. As per the FIR, the petitioner took photographs of the minor complainant, committed indecent act, made obscene gesture toward her and used abusive, filthy languages. Counsel for the petitioner submitted that the crime as alleged was not so heinous that it would warrant custodial interrogation or judicial custody. Thus, his client's mechanical and casual arrest should be avoided. In this status report, Delhi police clarified that the investigation was already underway, and when effort was made to arrest the petitioner, he absconded. Relying on the Supreme Court's decision in Sushila Agarwal and other versus state, the court reiterated that no offence stood excluded from the purview of Section 438 of the Code of Criminal Procedure. However, there were certain basic factors which court have to be considered while granting or not granting anticipatory bail, the court added. The Delhi High Court has rejected a petition filed by a professor and a dean of School of Mass Communication at Chitkara University, Punjab, demanding the quashing and setting aside of the appointment of Sanjay Dwivedi as the Director General of Institute of Mass Communication, Delhi. The plea also demanded setting up of an inquiry to probe into the alleged illegal appointment. The petition cited instances and alleged that in the past too, Sanjay Dwivedi had been appointed to the post of reader in RPV Bhopal, a petition against which was pending in the Jabalpur High Court. The petition attacked the very career graph of Sanjay Dwivedi, alleging a history of appointments without Dwivedi meeting relevant criteria. Against the present appointment, the petition alleged that minimum experience of 25 years was a prerequisite in the advertisement. It argued that an Dwivedi has acquired his master's degree in journalism and mass communication in 1995 to 1996, and the mark sheet was issued in December 1996. And as on the cut-off date, Dwivedi had only 23 years experience. The court noted that there was no averment in the petition that any statutory provision had been violated, and that in the absence of any averment as to violation of any statutory provision, writ in the nature of quo warranto is not maintainable. The Kerala High Court has made pertinent remarks on the freedom of press in the offence of criminal defamation while quashing a defamation case against the Malayalam Manorama. The bench of Justice P. Somaranjan emphasized that it was the duty of the press to publish all the news and comment on the same to enlighten society. Such commentary, the judge went on the highlight, was squarely under the first exception attached to Section 499 IPC when done bona fide in public interest. The first exception to Section 499 of the Code makes an imputation of truth for public good, a defence of criminal defamation. He added, the Fourth Estate is not expected to shy away from the matter governing public importance, but it is their solemn duty to serve the society with the news item with its pros and cons so as to bring the society more functional and vigil. Even if material published was sometime contemptuous, it could not attract Section 499 of the Indian Penal Code, the court additionally stated. Only if the material is published without good faith on a matter not concerning public interest or public good would the offence be attracted. The judge went on to declare the case arose out of defamation complaint registered against daily Malayalam Manorama in 2016. The daily had carried a story on a vigilance inquiry report against the complainant and the others. Their grievance was that they were described as accused person even before a case was registered against them. The Kerala High Court has a reserve order on the petition filed by the prosecution and the victim seeking the transfer of the sensational actor's sexual assault case to another court. A single bench of Justice A.G. Arun also extended the stay of the trial proceeding till the pronouncement of the order. The bench took the case after extensively hearing the special public prosecutor Suman Chakravarti and senior advocate S. Sri Kumar, who represented the victim. The prosecutor submitted that the trial judge remained a mere spectre when the victim was harassed and intimidated by the lawyer of the accused during cross-examination. When the prosecution expresses lack of confidence with the judge, the proper course would have been to write to the High Court informing about the same. But the presiding judge chose not to do so. The prosecutor submitted. Senior advocate Sri Kumar submitted that the victim was forced to undergo an ordeal of cross-examination for about 9 to 10 days, during which irrelevant and unnecessary questions maligning her character were raised. Most of the time, victim was weeping. I was compelled to speak about the horrific detail before a large group of advocates. The judge could not control the court. No judge would have allowed to put such questions to a victim of the horrific sexual crime. He submitted. The senior counsel went to the extent of submitting that there was manifest bias on the part of the proceeding officer. The Andhra Pradesh High Court recently pulled up the state police department for arresting person automatically upon the registration of FIR without regard to the safeguards against arrest under Section 41A of the Code of Criminal Procedure. Section 41A CRPC pertains to issuing a notice of appearance before the police officer when arrest is not necessary. The single bench of Justice Lalita Kanneganti was hearing a plea by a Telugu Desam party politician seeking to quash criminal proceeding against him under Section 153A of the Indian Penal Code. He was booked for a Facebook post that supposedly promoted enmity, hatred, and ill will among communities. The FIR was registered based on a complaint by the social media coordinator in the office of a member legislative assembly. The court questioned the judicial magistrate on why he remanded the arrestee to custody in this case and authorized detention in violation of Section 41A CRPC, finding that the lack of notice issued and the automatic arrest in this case violated the Supreme Court's decision in Arnish. The High Court sought a report along with the record from the magistrate on what basis Section 41A of CRPC was dispensed with and the accused demanded. The court has stayed the criminal proceeding against the petitioner and posted the matter for further consideration on November 26th. IAS officer floating court order should be punished with the imprisonment primarily, and other punishments such as the imposition of the fine in contempt proceeding should only be secondary. The Madras High Court has held the order of single bench of Justice S. Vaidyanathan warning bureaucrats was passed on a farmer's plea to direct Revenue Divisional Officer of Tenkasi to dispose his appeal under the Patta Passbook Act for the correction of patta entries in connection to a property he had purchased. The single bench noted that of late several cases are filed before the court with the prayer of disposal of application filed under Section 10 to 13 of the Act. This is the application for modification of entries in the patta, the appeal therefrom, and the revision arising out of the order of the appellate authority, and if those applications are disposed of by the authorities concerned in the time, the parties need not unnecessarily approach this court for such specific direction. The bench continued to state that if any physical verification is required, the authorities concerned must visit the spot and verify the same so that it will give a bird's eye view on the issue in question. It noted that in a case of grant compensation to a victim of electrocution, one of the sitting judge of the High Court had done a spot inspection in order to satisfy his conscience. The Karnataka High Court on November 13 directed the police to take all the possible steps to trace and arrest former mayor of the city, Sampath Raj, in connection with the Bangalore riot that took place on 11th of August. A division bench of Chief Justice Abhay Srinivas Oka and Justice Vishwajit Shetty passed this direction after it was informed that Raj, against whom a non-bailable warrant has been issued, is on the run. The court further directed the investigating officer to submit in sealed envelope by the next date of the hearing a report detailed the state taking to trace the accused. The court is hearing petitions seeking transfer of the probe into the incident to National Investigation Agency or any other central investigation agency. During an earlier hearing, two matters related to the riot were transferred to the National Investigation Agency. Raj, who is the sitting Congress corporator, has been accused of investigating the mob. The Karnataka High Court has held that an investigating agency cannot retain the username and password of the social media platform of the accused person during the investigation. The court said that the investigating agency should download and store the data required for the social media platform and should give back the changed login credential to the accused. An investigation agency cannot retain the username and password of social media digital platform like Facebook and YouTube pending investigation. The investigation agency can download the data required from such account and thereafter has to give back the changed credential to the person who own this said social media. Observe a single bench of the court made these observations in the judgment passed in the writ petition filed by Rakesh Shetty, the managing director and editor of news channel Power TV. Shetty had approached the High Court seeking to quash an FIR registered by the Bengaluru police against him after his channel ran a series of reports raising corruption allegations against the family of the Karnataka Chief Minister B.S. Yediyurappa. He also stated that the City Crime Branch (CCB) had asked him to share the login credential of his Facebook and YouTube accounts to investigate the extortion case slapped against him following the report against CM's family. After the username and the password were handed over to them, the CCB changed the login credential of the social media account, denying him access to them. The court ordered the CCB to hand over the new login credential to the petitioner within 7 days. The court also allowed Shetty's prayer seeking the return of the servers, laptops and hard disks seized from his office and residence. The court ordered that the petitioner was at liberty to file an application under Section 451 CRPC before the lower court seeking the return of the electronic equipments. Well, that's all in Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.